US. Whirlpool then filed a petition for certiorari, I hope I pronounce this correctly, with the US Supreme Court. And now we first need to look at what the petition for certiorari is. And that is, if we follow the history of this case first, in December 21, we had the US Court of Appeals decision. Then the US Court of Appeals apparently heard a request for rehearing, and they denied that. Then Whirlpool went to the US Supreme Court with this petition that we're going to look at. The IRS then responded to Whirlpool's petition. Whirlpool and others responded to the IRS response. And then on 21 November 2022, the US Supreme Court denied Whirlpool's petition, right? So if we look at what a certiorari is, and I'm relying on Wikipedia here, it says in law, a certiorari is a court process to seek judicial review of a decision of a lower court or government agency. Certiorari comes from the name of the English prerogative writ issued by a superior court. It must be a higher court, in other words, to direct that the record of the lower court be sent to the superior court for review. The term is Latin for to be made certain and comes from the opening lines of such writs, which traditionally began with the Latin words certiorari volumus. And if we look a bit at the English history of this, because that's where it started, and remember, US law largely historically follows English law. As time went on, the certiorari evolved into an important rule of law remedy. Certiorari is used to bring up into the High Court the decision of some inferior tribunal or authority in order that it may be investigated. If the decision does not pass the test, it is quashed. That is to say, it is declared completely invalid so that no one needs to respect it. The underlying policy is that all inferior courts and authorities have only limited jurisdictional powers and must be kept within their legal bounds. This is the concern of the Crown for the sake of the orderly administration of justice, but it is a private complaint, the certiorari writ, which sets the Crown in motion. And this was taken over by the US, and the practice in the US, as described by Wikipedia, is summarized here as Associate Justice James Wilson, 1748 to 98, the person primarily responsible for the drafting of Article 3 of the US Constitution, which describes the judicial branch, explains in every judicial department, well arranged, well organized, there should be a regular progressive gradation of jurisdiction, and one supreme tribunal should superintend and govern all others. An arrangement in this matter is proper for two reasons. The Supreme Tribunal produces and preserves uniformity of decisions throughout the whole system, so you don't get courts contradicting each other within the same country, and it confines and supports every inferior court within the limits of its jurisdiction. So Whirlpool requested that the Supreme Court look at this and simply throw this decision out for a number of reasons. So what were these reasons? If we look at the bottom of this is a table of contents of Whirlpool's writ, and it says the reasons for granting the writ. The Sixth Court decision conflicts with the court's precedent. The Sixth Court decision also contravenes the fundamental principles of administrative law, and the question presented is exceptionally important and warrants this court review. And you can also see Whirlpool did a lot of lobbying work here, because it filed its petition in June, and then in August it got the National Association of Manufacturers to file to support the request by an amicus curiae. It got its advisors, PricewaterhouseCoopers, to file the same. PricewaterhouseCoopers is of course not a business, it's a consultancy, so they're not manufacturing anything. And then they also got the Silicon Valley of Tax Directors Group to file for this. So Whirlpool was putting a lot of punch behind this request to allow them to make things in Mexico, sell them in the US, and not pay tax anywhere. And let us see what the different arguments were. Whirlpool said the Sixth Court decision conflicts with this court's precedent, and it says the decision below conflicts with this court's long-standing precedent on whether a statute conditioned on the promulgation of regulations may be enforced without regards to such regulations. Whirlpool simply said, you know what, the court only looked at the law, it didn't look at the regs. We said the regs were wrong, and therefore we should not pay any tax. And then they quote Dunlap versus United States, which the IRS referred to as a 135-year-old decision, which is obviously quite old. The IRS said because Section 954D2 is self-executing, in other words, the language is very clear, we don't need to do anything, and it says application here is straightforward, the Court of Appeals permissibly declined to articulate a separate rationale based on the regulations. Remember, Whirlpool said that the regulations were wrong, and the court said, I don't need to look at the regulations because the law is clear enough in itself, right? The IRS goes on to argue Section 954D2 is critically different from the statute in Dunlap. The statute in Dunlap, which is what the Whirlpool quoted, conditioned the manufacturer's right to a rebate on the showing that he had complied with the IRS regulations. That meant that without any regulations, the rebate right could not be vested. In contrast, 954D does not condition any right to obligation on showing related to the Secretary's regulations. So the Dunlop case apparently had something where they said, IRS must say what the rules are for getting this exemption, and if you follow the rules, then you can get the exemption. But as long as the IRS doesn't issue the rules, you can't get the exemption, right? And this case here was very different. The second argument of Whirlpool was that the Sixth Circuit's decision contravenes fundamental principles of administrative law. It is well settled that regulations bind the agency unless they are found to be invalid. Likewise, when an agency decides a matter based on a particular regulation, a reviewing court must review the matter on the same basis. So if the agency made an adjustment based on the regulations, the court cannot go and confirm that adjustment based on the law on which the regulations is based, is the argument. And the IRS says, as an initial matter, the first cited principle does not apply to tax deficiency proceedings at all. So not when the taxes are wrong. Under SEC versus Chenery Corp, a reviewing court must judge the propriety of such action solely by the grounds invoked by the agency. But here, there is no determination or judgment which an administrative agency alone is authorized to make. So now we're getting into quite some technicalities which are very US specific on whether you need to look at the regulations and the law, or whether you can ignore the other. I'm not going to spend a lot of time discussing this because it's not that relevant in the international context. The IRS then went on to say petitioner's contention that the IRS failed to follow the regulations is likewise unfounded. So basically this argument is not relevant. The IRS relied on both the statute and the regulation in arguing that the income at issue qualifies as foreign-based company sales income, right? And the third argument is quite interesting, right? Because Whirlpool says the tax implications of this case are enormous. To the extent the Sixth Court majority believed, it goes on to say Whirlpool alone faces the prospect of tens of millions of dollars of additional tax liability because of the decision below, right? So it complains about its tax rate being increased from 0% to the US tax rate. To the extent the Sixth Court majority believe that the result is justified because Whirlpool avoided any taxation at all, it is plainly wrong. Every penny of the income at issue here will be taxed by the US when it is repatriated. Moreover, the lack of immediate US taxation was correct because, as Judge Nalbandian recognized, this was a dissenting judge in the appeal court decision, the income is from manufacturing appliances in Mexico. It is not foreign-based company sales income and is nothing like the artificially separated sales income that FBCSI exception targets. Now, I find this argument of Whirlpool especially perverse, right? They said, we don't understand what the issue is here because we will pay tax when we repatriate the money. That argument completely ignores the very purpose of CFC legislation. The governments got tired of waiting to tax the income until it is distributed. Therefore, they incorporated CFC rules, and these regulations are the implementation of those CFC rules. To say, why did you just wait until we pay the money is a really strange argument you shouldn't have to pay a lawyer to come up with, right? And it goes on to say a broad coalition of amici curiae have filed briefs underscoring the significance of the decision below, and the spillover effect from the Sixth Court's majority decision is likely to be substantial. Trying to drive fear into the heart of the US Supreme Court because companies in the US will have to pay tax on their profits. The IRS responds rather simply. It says petitioners incorrectly claim that this case raises issues of exceptional importance. Petitioners principally submit that many taxpayers have relied on Treasury Department Section 954(d)(2) regulations, but the Court of Appeals did not question the validity of those regulations, and they didn't, nor did it suggest that they will not govern many of the cases, right? Petitioners' narrower concern about the effect of the decision below on maquiladora companies and the branch structures like those at issue is also unfounded. Although the former version of the regulation applies in this case, the current regulation, which took effect as after 2009, remove any doubt that there may have been raised by the dissent below about whether the sales income produced by such a branch structure counts as the CFC's foreign-based company sales income. And this is a very interesting paragraph, because the IRS indirectly does admit that maybe their first regulations were not perfect, right? And that maybe there was some unclarity, and that maybe there was a beginning of a case for Whirlpool as to why they relied on this case. And there must have been, because if a lot of other companies use the same structures and the same tax planning, it can't be completely baseless. The fact that a lot of other companies use it, of course, also doesn't mean that it was right? The IRS goes on to say the resolution of this case therefore lacks prospective importance for taxpayers who use branch structures like the one here, because the IRS said, maybe our earlier regulations were not clear, but we fixed that after 2009. So changing this case doesn't matter because we already fixed the regulations, right? And then they refer back one more time to the US CFC rules, and they do actually address about the issue of whether the former regulations were unclear or not. And they say resolving the question presented will not even make a difference in petitioner's own case. As the tax court's thorough opinion shows, the 2009 income at issue is FBCSI even under the former version of the regulations. And it's true, the court has decided that. The former regulations state that the FBCSI does not include income of a CFC derived in connection with the sale of personal property manufactured by such corporation, right? And as petitioners observe, the provision excluded from the FBCSI the income that a foreign subsidiary earns from the selling of goods that it manufactures itself. But here, Luxembourg is the relevant CFC, so income that Lux derived from selling personal property manufactured by Lux itself would not count as FBCSI. But Lux itself engaged in no manufacturing, so Lux cannot qualify for the manufacturing exception, and its sales income was therefore FBCSI under the former version of the regulations. That result is confirmed by example 2 of those regulations. Whirlpool then went on to respond to the response of the IRS. And as you can see here, the arguments are still the Commissioner's response rests on a patently revisionist history of this case. The Commissioner's defense of the decision below is based on a blatant misreading of the statute, and the Commissioner's attempts to mask the importance of this case fail. Pretty strong language, and ironically, the decision from the Supreme Court that we have now is nothing more than a list of certiorari requests which have been denied, including the Whirlpool one. So the Supreme Court was not impressed with Whirlpool's arguments or with the fact that they got half of corporate America to back them. I don't know if the Supreme Court will publish more information on this. I don't know what the US rules on this are, but I hope you enjoyed this case. Next week we will discuss something else, probably transfer pricing, and we'll leave this case as is. I think there are some interesting thoughts still to share in terms of why did the IRS not go for a transfer pricing adjustment here, but maybe that was not possible considering the hybridity of the structure. And second, how would the structure pan out under Pillar 1 and Pillar 2? I don't think Pillar 1 will have a huge effect because there may not be that much sales that are not taxed in Mexico, maybe some in Luxembourg, but not a lot. But Pillar 2 definitely would move the Luxembourg taxable income to a jurisdiction where the tax should be picked up. Time will tell how that will pan out. I look forward to discussing our next case with you another time. Bye for now.